Hello, I'm Amanda Moore. I'm the director of the Clearinghouse Community. Welcome to the Advocacy Exchange for August 2017. The Advocacy Exchange is our monthly conversation with advocates advancing change. Both the Advocacy Exchange and the Clearinghouse Community are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. And today I have with me Seth Lyons. Seth is a staff attorney in the employment unit at Community Legal Services of Philadelphia, and I'm happy to have him here. Hello, hi Seth, how are you doing?
Great, thanks for having me, Amanda.
So Seth is here today because he wrote this month's Clearinghouse article. It's called Risks and Rewards, Is Record Clearing Right for Your Non-Citizen Client? And you can find it at the address here on your screen. It's povertylaw.org/clearinghouse. It examines the relative risks and rewards of clearing a client's criminal record depending on that client's immigration status, and that's what we're going to talk about today. But before we get started, I want to tell you how you can be part of this conversation. We welcome your questions. We'd love to hear your feedback. If this is something that you've worked on and you have a tip to share or something like that, please let us hear from you. I see some of you have already found the live chat box on YouTube Live as you're watching. So hello to Heather and Kelly in Chicago. Thanks for tuning in. If you are watching through YouTube Live, you'll see that there is a live chat box there on your screen. You can send us questions and comments that way during the broadcast, and we'll be checking that. So if you want to go ahead and test it out, you can send us your name and where you're watching. We would love to hear from you. If, however, live chat's not your thing and you'd rather use email, you can do that too. My email address is here on the screen. It's Amanda Moore, M-O-O-R-E, @povertylaw.org, and I'll be watching that too during the broadcast, so feel free to send your questions that way as well. So everyone who registered for today's broadcast will receive a follow-up email in the next couple of days. In that email, you will find a link to Seth's article, a link to today's recording, and a link to register for next month's Advocacy Exchange. So keep your eye out for that. So let's go ahead and talk about why we're here today. Seth, we have covered quite a bit in the Clearinghouse over the past few years about the harmful economic consequences for our clients of having some sort of record in the criminal justice system. Sometimes even just an arrest record can have pretty serious consequences. But we've never talked specifically about the additional layer of a client's immigration status, the additional layer of consequences if that client is not a U.S. citizen. So can you briefly talk about that intersection for us and tell us why immigration status adds this extra layer of complexity to criminal records issues?
Sure. So let me first say that I'm not an immigration attorney. I have some background and understanding of the intersection between criminal law and immigration law, but I'm definitely not an expert. So I'm kind of coming at this from the point of view of an advocate who works with immigrants in a lot of different contexts, but does not practice immigration law. And this really came up because we at Community Legal Services do a lot of expungements, including for a lot of immigrant clients, but we weren't really thinking about these issues on a consistent basis, at least, in terms of what we should be considering. Are there any differences or any risks or different limitations when we're doing expungements for immigrant clients? So I started looking into these issues a little bit more and then developed kind of internal protocols for our unit, and that has been expanded into some general guidelines. And I say general because it's very specific to where you are and it kind of what kind of mechanisms there are, and I can talk a little bit more about that later. So the short answer to your question is that in addition to a lot of the collateral consequences that we think about when we're doing expungements for clients, criminal records can have really severe consequences for immigrant clients. In a lot of different contexts. It can be from denial of immigration applications like for citizenship or for some type of relief from deportation, for green cards, things like that, or for when you're coming back into the country if you're a green card holder, to being targeted for deportation or actually rendered legally deportable. So this kind of raised two general questions for me when I was working with immigrant clients is one, can record clearing petitions, expungement petitions, things like that actually help address some of these immigration consequences? And two, were there any immigration-related risks that we needed to be thinking about when we were filing petitions on behalf of immigrant clients? And I should say along those lines that especially with the risk issues, that there's not necessarily agreement on all of these issues from different immigration experts. I've talked to immigration experts in different parts of the country, and they don't always agree on this. So in the article and just in general, I'm trying to strike a balance between these different viewpoints and kind of talk about what potential risks there might be and ways that you can minimize those risks. But I think the main takeaway for me in my work especially has just been to think critically about these issues on a case-by-case basis and try to get the advice and expertise that you need to responsibly advocate for and represent immigrant clients in non-immigration contexts, and specifically with criminal records issues.
Got it. Thank you. And, you know, I'm assuming that there's kind of a new urgency for advocates to understand this, given the Trump administration's kind of prioritizing of immigration enforcement. Yeah,
that's definitely true. I mean, first, though, even before Trump's new policies on enforcement priorities in the immigration context, many of these issues already existed. But what President Trump's new policies have done is expand the number of non-citizens who are targets for enforcement. So whereas under Obama, it was really focused on people who had felony convictions or serious misdemeanor convictions, now basically any criminal record can make someone a target. And perhaps most importantly, in a lot of the work I do with people who just have arrest records and might not even have a conviction, is that people with arrest records who have never been convicted of anything can still be a target for immigration enforcement under the new priorities that were created in January of this year. So we don't really know exactly, it hasn't been that long, so we don't know exactly how those shifts in enforcement priorities are going to affect, especially in the expungement context, affect the risks of filing petitions on behalf of clients or bringing clients to court and things like that. But for me, it made me think a little bit more critically as an advocate about whether filing petitions in someone's name or bringing them to court puts them at greater risk. Or again, on the flip side, whether filing an expungement petition can actually help them and maybe remove them from the immigration enforcement authorities' radar. So the answer is that a lot of these issues have already existed, but with the increased emphasis on immigration enforcement based on criminal records, there's definitely more urgency to this work and to understanding these issues now.
Gotcha. Well, let's talk about some of these possible risks and benefits of record clearing. So let's start with benefits. So the analysis for benefits is a bit complex, and there are a lot of different factors that you lay out in your article when you're weighing these things. So can you talk a little bit about what those factors are that you look at when you're considering the possible benefits of record clearing for a non-citizen client?
Right. So like in general, and this all gets really complicated, and I'll say that every time I start to go through this analysis, I often get kind of turned around and confused. But there's, just some general factors or things you should think about. One is the purpose of expungement, whether it's addressing an immigration issue or if the purpose is just to clear this record for to address traditional collateral consequences like employment or housing, what the client's immigration status is, whether they're, assuming they're not a citizen, then if they're a green card holder, if they're undocumented, if they have some kind of temporary visa, things like that, the jurisdiction where you're located, the type of record clearing mechanism, whether it's something that attacks the actual the validity of the underlying conviction, or if it's something that just kind of hides that information from public view. And there's several other factors that I'm sure people should think about that, when you're going through these cases on an individual basis, issues will come up.
Right. And you do go through quite a few of those in the article. So I'll remind people, while we won't be able to get to every detail that's in there today, they should check out the article. So I want to focus on potential benefits of kind of looking at one of those factors that you mentioned, which was the purpose, why it is that you're considering clearing, filing an expungement or trying to clear this criminal record. So let's say that this is for immigration purposes. It's not just for general getting rid of those collateral consequences, but you're doing this for an immigration purpose. Can you walk us through that analysis?
Sure. So within this analysis, and again, this is just looking at whether you're trying to do something, if you're trying to clear a record for the purpose of helping relieve some kind of immigration consequence, it's helpful for me to break this down into two categories based on the type of record clearing mechanism. So on one hand, I have what I refer to as standard expungement procedures, which usually, again, just either hide that information from public view or even destroy that information so that even the police or courts might not have access to that information. But it doesn't do anything to change the very fact of somebody's conviction. It doesn't attack the validity of that conviction. It doesn't change something about that conviction, right? So it's just kind of deleting or hiding the information. And there's different words for this. Some people call it sealing or expunction or expungement. It depends. It's very state by state. But that's the general idea for that first category. And this is in contrast to other kind of post-conviction relief mechanisms that attack the underlying conviction or change something about the sentence or the classification of that conviction. The former, a standard expungement procedure, generally, and this is a general idea, does not address immigration consequences, whereas the latter may. So there are exceptions. So for a standard expungement procedure, and I'll say, first, I guess I'll say that there's kind of two reasons that a standard expungement procedure doesn't usually help with immigration issues. The first is that legally, under immigration case law, it's been held to not help. So there's a case called In re Pickering, which basically said that if a court vacates a conviction for any reason that's unrelated to the merits of the underlying criminal proceedings, so it might be specifically to address immigration issues or maybe just for some other issue, that person still remains convicted for immigration purposes. So even if for all other contexts, even if in your state law you have something that says that an expunged conviction doesn't count as a conviction when you go to apply for a job, that is not true in the immigration context. The second is kind of logistically, and that's that it doesn't necessarily eliminate that information from immigration authorities may still have access to that information, even if the local state authorities don't. And this is a little bit complicated. And this was something that I thought in our state, where in Pennsylvania, for example, you can actually, when you get an expungement, all that information is actually destroyed. Like the case file is physically destroyed. The police don't have access to it. The courts don't have access to it. And I thought, well, if we can do that and expunge maybe an arrest that never resulted in a conviction, maybe that can take people off of Immigration Customs Enforcement, ICE's radar, because there right now as an enforcement priority for them is deporting people, picking up people potentially who just have arrest records. Well, if we can delete that arrest record, would that help somebody to avoid immigration issues, right? And from what I've found from talking to different immigration people is that it does not. So ICE, and that's because at the time of arrest, ICE automatically gets information about any person who's arrested in this country. So at the time that somebody is fingerprinted, that information is automatically shared from the state authorities with the FBI, and then the FBI automatically shares that information with Immigration and Customs Enforcement. So eliminating that record from a state level database, even if it gets pushed up to the FBI database, which in Pennsylvania, if you expunge something in Pennsylvania, theoretically and often it does work, it gets pushed up to the FBI and they actually delete it from their database, but ICE will still have will have a record of that initial arrest. So it's not going to take them off of ICE's radar. There are certain exceptions to this, and I mentioned in the article, for example, with DACA, which is Deferred Action for Childhood Arrivals, there's certain types of immigration applications where an expungement can help remove certain bars to immigration relief. There's also specific to certain jurisdictions, like there's something in the Ninth Circuit with arrests for certain types of drug convictions before 2011. It all gets very specific. So again, I would say that talk to local immigration experts about these issues, and there's some good resources that I can talk about. But the general idea is that these standard expungement procedures don't usually help relieve immigration problems. In contrast, there's this kind of group of post-conviction relief mechanisms that can help for immigration purposes. The first most important one that probably most states have are pardons. And that's because there's a specific statute or specific section of the Immigration Nationality Act, the INA, that says that convictions that are pardoned by a governor or the president no longer count as convictions for immigration purposes. So pardons are great if you can get them. There's also another kind of set of post-conviction relief, like vacator, and there's some state statutes that have enumerated reasons for that somebody can actually attack the validity of a conviction after the fact. Often it's for, one really important thing is ineffective assistance of counsel, which in the immigration context can be a really great tool for attacking the validity of a conviction after the fact, and that can undo the fact of that conviction and make them no longer deportable or no longer barred from certain types of immigration relief because of that conviction. And then there's a few kind of more recent laws that are creative and sometimes specifically intended to address immigration consequences. For example, in California, they have some really great laws that allow somebody to either change the sentence, reduce the sentence, or change the classification of a conviction from a felony to a misdemeanor after the fact, potentially after you've already served your sentence. And what that can do is that because some grounds of deportability under statute, under federal law, depend on sentence length, either the actual or the potential. So actual time served or the potential sentence length, the maximum possible sentence. Reducing the sentence or reducing the classification from a felony to a misdemeanor can make that state conviction no longer count as a deportable offense under federal law. And again, that gets really complicated and gets into work that I would never do because I'm not an immigration expert and I don't represent people in immigration proceedings. But it's just something to think about, that if there is some mechanism like that in your state, it might be something that can help your clients avoid immigration consequences. And talking to immigration experts in your state is a great way to figure that out.
Great. And I'll remind our viewers that we would love to hear from you. We'd love to hear your questions. You can send us those in a couple of ways. As you watch through YouTube Live, you can use the live chat box and send a question. You can also email me at the address on your screen, Amanda Moore, M-O-O-R-E, @povertylaw.org. So Seth, you just described the possible benefits, looking at that if you're trying to get an immigration benefit. That would be the purpose of this type of record clearing. So what about what we think of as the more traditional reasons for clearing a record, getting rid of those collateral consequences? Just it happens that your client is an immigrant. How do you look at the possible benefits in that situation?
So that's a great question, and one that I am always trying to remind myself to think about and think critically about this. The basic answer is that for anybody, generally for anybody who has a work visa, the benefits, at least in the employment context, the benefits will be the same as for citizens. And I talk about the employment context because that's the area where I practice more, and we do some expungements for housing as well as community legal services. And I know there's other reasons that people do expungements, but kind of thinking this through, it's a similar type of analysis in terms of will this help and how will this play out, right? If you expunge this from somebody's record, will this actually help them get a job or housing or whatever? So in the employment context, if somebody is a green card holder or an asylee or a refugee or holds a visa that comes with a work permit, expunging the record will be pretty similar to how it helps citizens, in that it clears that information from the record when they go to apply for a job. An employer won't see it, and that hopefully will help them get that job and help them not be denied because of their record, right? For undocumented clients, it's a little less clear. At least in the employment context, if an employer is doing serious background checks, it's likely going to come up that that person is not authorized to work in this country. So they're more likely to be denied because they're undocumented, because they can't legally work in the country, than because of their criminal record. So having a criminal record on top of that won't necessarily help them. Now, that might not be true in every context, and that's why I think it's important to talk to your client about maybe what the procedures are for applying for a job and what kind of background checks they have to go through to see if maybe this can help in that context. And there's some circumstances, like I'm saying, that's not necessarily true. For example, with occupational licensing, where in most states and for many different types of occupational licenses, they have to do a background check before they'll grant you an occupational license, and they may deny you because of your record. Well, in California, for example, they're allowed to consider criminal backgrounds, but they're not allowed to consider your immigration status when deciding whether to grant you an occupational license or not. So if you're able to actually clear somebody's record, even if they're undocumented, that might open up a pathway to getting an occupational license, which then helps them get a job that might not have existed had you not done the expungement. So again, I think it's just really important to talk to the client about why they want an expungement and think through all these steps to see if it will actually address that issue, and then balance that with whatever potential risks you identify.
Right. So let's talk about those. What are some of the biggest risks? I mean, you've laid out some pretty nice benefits. So what are some of the biggest risks?
So again, these risks are not always clear, and it's probably going to depend on each individual case. But there's kind of two general areas that, at least how I think of it, where this can create problems for people. The first is pretty straightforward. It's just, is there a risk in filing a public document on behalf of an immigrant client, specifically a public document that identifies that person as having a criminal record, or bringing that client to court, right? So we don't know at this point what immigration authorities are doing in terms of, are they reviewing public filings? That seems maybe unlikely, but to the extent that you can kind of avoid putting as much identifying information about a client on a petition out there, the better. And we don't know this, I guess, actually, for bringing clients to court. We have seen those issues popping up more and more. I haven't seen anything where an expungement petition in particular triggered ICE coming to court and picking up a client. But we've seen it, especially in other types of criminal cases, or even in some civil cases where ICE is hanging out at courthouses and picking up immigrants. So to the extent that you can avoid having to bring a client to court, that's definitely the best thing you can do. So there's risks just generally about, there's potential risk, I should say, generally about bringing clients to court or filing public documents on behalf of immigrant clients. The other issue is one that I hadn't really ever thought about, which is that it can, in some circumstances, expunging a record, actually destroying that information or hiding that information or making it not accessible, can make it more difficult for clients to obtain certain immigration benefits by making it hard to get documentation that they need to prove to immigration authorities that they're actually eligible for those benefits. So again, in Pennsylvania, when we do an expungement, we destroy all that information. But when somebody goes to apply for citizenship, for example, they will have the burden of proving that they are eligible for citizenship and not barred by some of the criminal record bars. But if they don't have access to the information, like they can't get certain copies of the court files to show what happened in that case, immigration authorities might deny that application for relief. And that's what this issue is something that we saw from talking to our friends over at Friends of Farm Workers, who do a lot of these types of cases, and have seen cases either delayed or denied, applications for citizenship delayed or denied, because somebody had expunged the record and didn't have access to necessary documentation. Another part of that issue is that in some states, when you do an expungement, when you get an expungement, you're told that you no longer have to report that conviction on a job application or housing application or whatever it is, but that's not true in the immigration context. And because, like I said before, ICE seemingly has its own database of arrest information and will know that there was an arrest at some point, if you fail to disclose that on an immigration application, that can be a ground for being denied. So it can be sometimes misleading, and you got to make sure that clients understand that just because something has been expunged under kind of a standard expungement procedure does not mean that they don't have to talk about that on an immigration application. They don't have to disclose that in an immigration application, and that they need to make sure that they get certain documentation that you need to prove what happened in that case and that you are eligible for those immigration benefits.
Right. So I think you're kind of answering a question that just came in from Lindsay in Chicago, who was asking about, if someone who may want to expunge the record, but they're hesitant to do so because ICE may want more information on the case if they move towards citizenship. And she was asking if it's useful to order the file in their case and make a copy for their records. That way they have the information
yes,
if the question ever comes up.
Yes, with an important caveat, which is that a standard copy of that case file may not be enough for immigration purposes. And I don't know that there's a hardline rule on what is sufficient, what kind of documentation is sufficient or not. What we do at Community Legal Services, kind of as our rule of thumb, and this is just from talking to lots of different immigration experts, is what seems to be enough is certified documents from the court. So we can order documents from the court before the case is expunged that show, importantly, that show the disposition of those charges. So that show that maybe that their charges were dismissed, or if it shows a conviction, whatever it is. But ICE immigration, and this is more on the immigration application side, so it's U.S. CIS, Citizenship and Immigration Services, will want to know what happened in that case, and they will want a certified disposition. So it's a document that specifically has a stamp on it, and it has to be the original. That's what our rule of thumb is, at least. So a copy is not necessarily enough. This can raise other issues about maybe somebody wants to apply for citizenship down the line, but is not ready to do so yet. Maybe they're not eligible. Who know? Are they good at? You think that your client will be good at maintaining those records? Do you want to try to get an extra certified copy that maybe you will have the client give to their immigration attorney, or maybe you'll be able to keep a record for them? So, to the extent possible, to get these certified documents and make sure that they're maintained in a safe place is what we do at this point.
Gotcha. We had another question come in from Christy in Florida. And this is a kind of a general question about expungement. And so she asks, she's heard that even if clients are able to seal or expunge criminal records, the private companies that employers use to run background checks will still have the criminal record info. And she's asking, is it still going to show up, basically, even if I do this? And can I remedy this? And I'll preempt Seth a little bit here to say that one of his colleagues at Community Legal Services, Sharon Dietrich, wrote a piece for us about this a couple years ago, and where she talks about this this very issue, when the criminal record won't die. It's like a zombie, right? And we will include a link to that in the follow-up email that goes out after this. But Seth, I want to also give you the chance to answer this if you have just a couple. We're nearing the end of our time, so if you have a couple of quick answers to Christy's question.
Sure. I mean, the quick answer is to read that article, because Sharon knows way more than I do about this process. But basically, in most states, at least, if something's expunged or sealed, it should not be showing up in commercial background checks. And there's ways that you can dispute the accuracy of those background checks to correct that information. And there's also, under the Fair Credit Reporting Act, there's potential remedies for a client if somebody incorrectly reports information on a commercial background check like that. So there's different options. I'm not an expert on this issue, although we do work on those at CLS. But Sharon is a great resource for that, and that article explains a lot.
We are nearing the end of our time. I see we've had a couple more questions come in. I'm afraid we're just not going to have time to get to those. I will pass them along to Seth after the broadcast, though, so he can answer you directly. I want to ask you one kind of last question, though, Seth, to make sure we get to it. So you've given us a lot of good tips. I just want to see if the attorney and the client go through this, they decide it is worthwhile to proceed with some sort of expungement or record clearing process. What kind of tips? You've given us a few. Do you have other tips for that attorney to make sure that they are minimizing those risks after they've analyzed them? What can they do to minimize them?
Great. Well, besides getting certified copies, which I've talked about, I think that's one of the first steps. Other things are, and this can be, it's kind of dependent on what the procedures are like. For example, in Philadelphia, and this is specific to Philadelphia, we don't, at the first, when you file an expungement petition, you first go to court and have basically a status hearing with the trial commissioner, where if the district attorney doesn't object, the petition is automatically granted. And there's no opportunity for a client to testify or participate in that hearing in any way. So there's really no reason to bring the client to court. So if you're able to not bring your client to court and it's not absolutely necessary, that's one way to think about it. Just, we, as a matter of course, we're bringing all of our clients to these hearings at some point, and we just started thinking, well, is this really necessary? And for immigrant clients, if it's not, we probably shouldn't be doing that. Even if right now we're not seeing those issues at court, and it's just better to not have them come in, because you never know what's going to happen. You never know if ICE is hanging around the court and they could get caught up in something else. Another thing that we do, and again, this is just whether they accept these types of filings. in your state is that we use a care of address. We'll use CLS's address on the actual petition, and maybe try to, like, for some immigrant clients who have multiple last names, but maybe we can just use one last name on the actual petition. If you're able to use as little identifying information on a public document that you're filing with the court, that's better. So we try to use a care of address and not give more information potentially to immigration authorities than is absolutely necessary.
Got it. Thank you. And I want to thank you just in general for being with us today, and also thank everyone who tuned in. And I want to tell you just a couple other things. I'll remind you that you can read more from Seth in his article, Risks and Rewards, is Record Clearing Right for Your Non-Citizen Client. You can find that at povertylaw.org/clearinghouse, and also look out for that email coming your way. It'll have a link in it to the article. If you found today's advocacy exchange interesting and you'd like to be notified of future events and articles that we publish, please join our mailing list. You can find that at connect.povertylaw.org/clearinghouse. And I'll also remind you that the Advocacy Exchange is now available as a podcast. You can subscribe to the Advocacy Exchange on iTunes or wherever you subscribe to podcasts. And I'll invite you to join us for next month's Advocacy Exchange. I'll be joined by Esme Caramello, the Faculty Director of the Harvard Legal Aid Bureau. We'll talk about a different kind of record that can limit our clients' access to housing in particular, and that's a record from having been in housing court, and how that can put some clients on a tenant blacklist. So my conversation with Esme will take place on Wednesday, September 13th, same time as today, 1 o'clock Eastern and 10 o'clock Pacific. And we hope that you will join us at that time. Until then, remember that you are not alone out there. Thanks.
Thanks, everybody.